Welcome to another episode of Legal for Tech, the podcast. So guys, today we are recording from the Privacy Symposium in Venice together with a great friend of our podcast. I decided you're a friend of our podcast.
Okay, we can be friends.
Thank you. Just for today.
But nothing more.
Friends on Facebook?
What?
Well,
I'm old enough to have a Facebook account, yes.
Of course,
I confirm.
Okay, so we are calling here from the Privacy Symposium in Venice together with Vincenzo Tiani. Hello, Vincenzo.
Hello. Thanks for asking me for this amazing... I'm sure it will be an amazing interview and in an amazing venue. I don't know if you will see all the venues that we have here in Venice, but I'm sure it's different, let's say.
It's a different venue from my kitchen normally. But anyways, Vincenzo, why are you here today? Who are you? What brought you here and to our podcast?
So, my name is Vincenzo Tiani. I currently senior EU Policy Counsel at the Future of Privacy Forum, which is a think tank that, as you can imagine from the name, works on privacy issues. And now, privacy is everywhere, so no digital regulation. And I live in Brussels normally, but it's every year since the beginning of the symposium, I come to Venice for this amazing event.
What a pain, huh?
Yeah, I could have gone to Dublin because there is another conference on AI, but I think I would say Venice in May could be more interesting weather and venue. So yeah, and so I studied in Italy, in Bologna, graduated, studied law. And then after a while said, actually, I would like to go abroad. Mm-hmm. And Brussels seemed a nice place to... No, it didn't seem a nice place to stay, but it became a nice place to stay. And then I did an LLM in IP and IT law because I wanted to specialize more on digital matters. GDPR was on the rise because it was 2015. Mm-hmm. Then if you go to Brussels, you need to do the Brussels path, so internship, European institution, one internship, two internship, and so on. And then I spent 4 years at Panetta law firm, an Italian, very prominent Italian law firm that works in privacy since the beginning. And then here I am since December at Future Privacy Forum.
So you started off in Italy, then you went to Brussels, and you've obviously seen everything basically in Europe, aside from Venice. There is a particularity, I would say, about the European Union institutions, especially when it comes to privacy and data protection, which is that you have a more central authority, so in this case the EDPB, for example, and then you have some specific tinier authorities in every state, and in some countries each constituency has its own. And these authorities act in a different way amongst each other and sometimes have very different views on specific things. So, in your experience, how did you see these authorities cooperating, and do they always reach an agreement?
So this is not a new question because this is an old issue, an old challenge. I would say. So first of all, I would say it's quite normal that different authorities can interpret in different way. So I would say that this is an old challenge, but it's quite normal, I would say. I think lately we forgot that law and lawyers, that's why lawyers exist, and judges exist to interpret the law. Because law is not just a list of stuff that you need to do. It's GDPR in particular. It's made of a lot of principles, and then it's up to data controllers, to company, to find their way. And yeah, it can happen, of course, that depending on your business, depending on your country, depending on the presidents or in your countries, the local DPA could act at the beginning interpret the law in a specific way. Again, we are talking about an horizontal framework. GDPR is not just for big tech or social media, but GDPR, it was written for any kind of business. It's handling data, personal data. So yeah, it's fair. That's why DDPP exists. DDPP, it's the European Data Protection Board, where every month, all the data protection authorities gather in Brussels to coordinate, to ensure, let's say, a proper and uniform interpretation of the law. And then, first of all, it takes time. It takes people. And I only recently find out how many people work in the DPP. Try a guess. Guess the number.
13.
No, okay, a bit more, but yeah, more or less 20. And if you think about how much work is there, opinion, guidelines, coordination, secretary for all the events that they have every month, plus any request, plus coordinate all these 27 data protection authorities, plus Germany, which is a special one. It's not nothing. I think it's quite a miracle that they can handle all this work. So yes, of course, there's a lot of one problem we know is that it takes time, and business would like to have answers like in tomorrow. But this is not an easy job, and so I would say with more resources, it will be easier to coordinate better data protection authorities. It's not impossible, but it's doable.
Okay, we have an optimist here.
Yeah, naive.
Actually, let's give a big background on the reason for this question and how we met you, Vincenzo. Because we participated in one of the panels here at the Privacy Symposium that was in Italian and was about the legitimate interests as a legal basis for the processing of personal data. And it was actually looking at how it is a mystery how this legitimate interest rule works, or if it is a legal uncertainty, so it's a gap of the legal framework and of its interpretation. And the first question I asked you is particularly linked to this issue because legitimate interest has a different interpretation basically in each of the 27 countries more or less, plus the ETPP has its own rule, plus it applies a bit differently depending on which company we're looking at, doesn't it? So what's your take on how legitimate is the legitimate interest?
So legitimate interest could be seen as a sort of wild card in the deck of cards. And why is it? Because it's not clear. I mean, consent, you know what is consent. Yes, no.
You do?
That's it. Yeah, I mean, we can do this, yes. Or no. Easy. I can withdraw, yes or no. I mean, it's more, let's say, easy to assess. Contract. You need to establish what is contractual necessity. But more or less, do I need this? Yes, okay, yes or no, easy. Legal obligation, there's a law, okay. Public interest, again. Vital interest, again, easy. Legitimate interest is, it's open to interpretation. Why is that? Because it is open to any kind of, let's say, not clear framework, not clear. You know you want to do something. The business wants to do something as an interest. There needs to be, the legitimate interest text and three-part test. And it needs, again, it's part of the accountability and fairness principles for the data controller to decide if there is a legitimate interest, if the interest of the company doesn't harm the fundamental rights of that subject. And again, this is not just written for big tech or social media, it's written for everyone. So of course it depends on the business, it depends on that specific situation, and it depends if this is just newsletters. If I want to send a newsletter without having consent because you bought a pair of shoes in my shop, or we're talking about data trading. Still the same legal basis, but totally different situation. So I'm not surprised that there are DPAs interpreting the legitimate interest in a different way because it's very specific, and I would say it doesn't work the same way when you take a court ruling or a measure from a DPA and then decide, okay, this is how it works. No, this is how it worked in that specific matter, in that specific situation, with these guardrails, with these safeguards in place, with this data retention policy. And then, then it worked. And in the other case, it didn't. Why? Because there wasn't any safeguard, there wasn't any sufficient transparency notice. So again, it's the law. It's not something that it's yes or no. It's not a checklist.
Although, when you talk about consent, you ask the user yes or no, right? Yeah. With legitimate interest, you're waiting for someone to proclaim what's legitimate interest. So should it be the authorities? Should it be the companies? Should it be the users? Who should say what's legitimate?
It's the company that in their assessment decide what is their interest. Of course, it needs to be legitimate, meaning of course needs to be lawful. If you want to, let's say, spam, say I want to do business. Okay, do business. Okay, find new clients. Okay, propose some deals or my products. Okay, how do you want to do it? So far, everything is okay, but how you want to do it? I want to just send emails everywhere. I just scrap emails from all over the internet and just send my proposals. It doesn't work because there are other parts of the assessment test. So again, it's up to companies, and it depends also from today. It could work because technology is at a certain level, and you know that with that technology, the risks are 1 to 3. Tomorrow we can have a new technology, same kind of interest, but the technology can do 4, 5, 6 if it's not controlled. So the same action in 3 years could be totally different, could require more safeguards because there are more risks. And so it's really, we know that if you work with the privacy, you know this is really a life cycle exercise. It's not just a checklist again. It needs to be in your DNA. It's not a goal, it's a process.
Well, you've touched upon something there that's obviously the content of my next question, and generally I want to ask this question. Technology can evolve, and there's a specific technology that's said to be evolving at every single second, and in a way that their programmers don't necessarily know. So they're not aware of how it's going to go and where it's going to go. So what are the greatest challenges you identify with this type of technology, which of course it's AI, just making sure? And also, in defining legitimate interest in the field and related to the topic of AI technology, do you think that it's too broad a concept for it to be applied onto AI, or should it just be scrapped off when it comes to that specific tech?
So I would say that if it's scrapped off, we can, close everything because the other don't work. The other legal bases don't basically work. They could work specific, let's say, moment for specific actions, but not to build AI. But again, I could sound like a very old man that keeps repeating stuff. The problem is that it depends, and it depends from what? Depends if you're talking about health, health data. Legitimate interest, we know it's with Article 9, special categories of data, it's not really the proper legal basis. So we cannot say legitimate interest yes or no. Again, it depends. If you study law, it always depends. That's the way I teach my students. The first thing, it depends. Then you need to explain how it depends. And I'd say it's if you are sufficiently transparent, if you explain what you're going to do with the data you need, you will use from the data subject. If there is a way for the data subject to expect what kind of use will be done with their data, let's say, without asking for consent in advance. If you grant the right to object, because it's true that right to object is for marketing, is for profiling, not for any, let's say, right to object without the necessity to give any, let's say, justification. And in other cases, you need to justify, and also the data controller could say, no, actually, we think that our legitimate interest stays. But if you want to grant, let's say, more safeguards, more rights for data subject, especially, as you said, we don't know actually AI how it uses all the data. It's not just an algorithm. It's A then B. It could be you put A and then you get C, and say how you get to C. We don't know, but still use my data. And so I would like to know how my data were used and for what purpose. So again, I know it's not the answer yes or no, this yes, yeah, or A, B, C, but this is the job, and I think it's a constant exercise of really thinking, and but also discussing, really having a proper confrontation, open discussion with the authorities, with other companies, with your peers, with the academia, Because if you just stay on your ivory tower, and no, I'm not talking just about the authorities, I'm talking about everyone. If you don't connect, you will not find out what's going on. If you just read the law but you don't know how technology works, it won't work. If you're an engineer, you just think about technology and you don't think about fundamental rights, it will not work. So that's really easy as it is, and again, very optimistic. But I would say it would be a very good starting point to start doing this.
And before I let you go, I promise this is the last question, but you've been saying that it's important to, keep informed and keep in the loop. So is there something that you want to share with us about what's to be informed about some projects that you've been working on?
So at Future of Privacy Forum, we are a global organization with we are more of 50 people in the US. We are covering basically every latitude, so US, EU, APAC region, Africa, and India. So let's say, as a global organization, we know what's going on globally. At European level, we recently published. My colleague Andrea worked on a conformity assessment guidelines. So if you're working on AI, that can be very helpful. Also, my colleague in the APAC region have worked on the recent South Korean AI legislation, which is the second basically AI legislation in the world, and they make also a comparison between AI Act and South Korea. And also it's interesting because perhaps I haven't read it yet, my bad, but it's true.
You've been busy.
Yeah. But it's true that you can, in this kind of discussion, you can find out that perhaps other government, other legislators decided to, create a new legal basis or new exceptions or new safeguards. So that's why it's very important to not just being focused in Europe. And this is really something I learned 2 years ago in Singapore, where I was with FPF invited at the time. Where I found out, for example, that at a certain latitude, like in the APAC region, where there are many small countries, they don't think it was the time to work on AI legislation because we don't have so much risk compared to European Union, 400, almost half a billion people, US 300 million people, China, India, where impact is quite important. And in other cases, I heard an expert saying, if you think about using LLM in Europe for medical advice, just like that, you would say, no, you're crazy, you cannot do that because there are fundamental rights, it can be wrong, hallucinations, so on. But it says, if we start to use LLM in Africa, in certain poor countries,
of course,
to get medical advice, medical quote unquote,
and nothing.
That's where doctors cannot get there, and we save life. So again, it's a constant balance, and it's not. I love Europe. I love how Europe regulates. So I'm on board on that.
He wants to stay in Europe.
It doesn't work the same way everywhere. So again, discuss. Go to conference like this, and go to podcasts. Discuss being challenged by questions and so on.
You're amazing at plugging, I have to say. Thank you so much.
I expect for my check for this endorsement.
Right. Can we cut this? By the way, this was all from the Privacy Symposium in Venice. Thank you to my colleagues who are here, who are recording, Giacomo and Giacomo. And thank you to Vincenzo Tiani for joining us today and for giving amazing panels, which we really enjoyed following.
Thank you very much.
This was all from Legal for Tech, the podcast.